Hello and welcome to LiveLaw Daily, your no-noise daily update on what happened in India's courts today. It's Tuesday of May 26th and the rise in the temperature along with petrol prices is showing no signs of slowing down. But the courts keep going on and so do we. So let's begin. Our first story has a question in it. What counts as a wetland in India and who gets to decide which water bodies deserve protection? That question reached the Supreme Court today in a case that could reshape environmental safeguards across the country. A bench led by the Chief Justice of India Suryakant and Justice Joy Mallya Bagchi was hearing a petition challenging the definition of wetland under the Wetlands rules of 2017. Senior advocate Gopal Shankar Narayan, appearing for the petitioners, argued that the 2017 rules dramatically narrowed the earlier definition and weakened protections for ecologically sensitive areas. According to him, the rules now exclude river channels, paddy fields, several human-made water bodies, drinking water tanks, and even structures used for irrigation, aquaculture, and salt production. He told the court that this could leave thousands of wetlands unprotected, including bird sanctuaries and dozens of previously identified sites. Shankar Narayanan argued that the impact stretches across more than 1 lakh wetlands nationwide. But Justice Joy Mallya Bagchi pushed back on one part of the argument, observing that earlier Supreme Court rulings based on the 2010 definition cannot stop the government from framing a fresh definition under new rules. Even so, the bench appeared concerned about how clear the current definition actually is, especially when comparing the ecological impact of different kinds of water bodies. The court has now limited its notice in the case specifically to one issue, whether the 2017 definition of wetland is unconstitutionally vague. For the second story today, the Supreme Court found itself confronting a different kind of backlog. Not pending cases this time, but empty chairs inside one of the country's most important tax tribunals. A bench led by Chief Justice of India Suryakant and Justice Joy Mallya Bagchi was hearing a petition filed by Praveen Kumar Bansal over long-standing vacancies in the administrative setup of the Income Tax Appellate Tribunal or ITAT. Senior advocate Mukul Rohatgi told the court that key posts across the tribunal have remained vacant for years, severely affecting its functioning. According to him, vacancies exist across the hierarchy, from assistant registrars to private secretaries and other staff positions too. And when the bench asked whether the issue was limited to few benches, Rohatgi responded that the problem exists everywhere, adding that some posts have remained vacant for nearly 10 years. I don't know how it functions, he remarked before the court. The submissions appeared to genuinely surprise the bench. Chief Justice Suryakant observed that the court itself was taken aback by why these posts had remained vacant for so long. The Supreme Court has now sought intervention of the Attorney General of India and directed that a copy of the petition be supplied to his office so the vacancies can be addressed at the earliest. The petition also seeks directions to urgently fill posts like Deputy Registrar and Assistant Registrar and to convene long-pending promotion committees that, according to the plea, have been stalled since 2015 and 2017. And for the third story here, the Supreme Court has granted bail to a senior bureaucrat accused of being one of the kingpins in the alleged Chhattisgarh liquor scam. A bench comprising Chief Justice of India Suryakant, Justice Joy Mallya Bagchi and Justice Vipul Pancholi granted bail to former Chhattisgarh Excise Commissioner Niranjan, who was arrested in connection with corruption and money laundering allegations linked to the state's liquor trade. While granting relief, the court made it clear that it was not expressing any opinions on the merits of the case, but during the hearing, the bench did take note of the serious allegations leveled against Das. The court recorded that Niranjan Das, who earlier served as Secretary of the Excise Department and later as Excise Commissioner, is accused of exercising control over the entire process and helping formulate a policy that allegedly enabled the scam. The bench noted that the prosecution describes him as one of the orchestrators and kingpins of the alleged scheme, which is also accused of causing major financial losses to the state exchequer. At the same time, the court noted several factors that weighed in favor of bail. Niranjan Das has been in custody since December 19th of 2025. Investigation against him is complete in both the corruption and PMLA cases, and the charge sheet as well as prosecution complaint have already been filed. The bench also noted that out of 9 accused persons, 8 have already been granted bail in the money laundering case. Observing that the trial is likely to take a long time because of the large number of witnesses and documents, the Supreme Court ordered Niranjan Das's release subject to conditions imposed by the trial court. For the fourth story, can a company chairman face criminal prosecution simply because of the designation he holds, even without allegations showing direct involvement? The Allahabad High Court answered the question. The High Court has quashed a 2016 criminal complaint and summoning order issued against Wipro chairman and managing director Azim Premji in an alleged labor law violation case linked to the company's Lucknow office. Justice Zafir Ahmed noted that the complaint contained no specific allegation showing Premji's direct role in the alleged violations or his involvement in the day-to-day functioning of the Lucknow establishment. The court observed that criminal liability cannot be imposed mechanically merely because someone holds a top designation, unless the law specifically provides for it or there are clear allegations showing active involvement. The case arose from alleged labour law violations at Wipro's Lucknow office. Before the High Court, Premji's counsel argued that the office's security services has been outsourced to G4S Secure Solutions India Private Limited, which was independently responsible for wages, Provident Fund, ESI and compliance with labour laws for its employees. The court also noted that Premji lives in Bengaluru, had no managerial control over the contractor and was not involved in the daily operations of the Lucknow office. While quashing the proceedings, the High Court further observed that summoning an accused in a criminal case is a serious matter and courts must apply judicial mind before issuing such orders, instead of passing them mechanically. And for our fifth story today, the Supreme Court is now taking a closer look at the Delhi High Court ruling that relaxed attendance requirements for law students. And the judges had some pointed questions during the hearing. A bench of Justices Vikram Nath and Sandeep Mehta issued notice in a petition filed by the Bar Council of India challenging the Delhi High Court order. The matter has now been tagged with pending petitions questioning BCI circulars on criminal background verification, biometric attendance systems, and CCTV monitoring in law colleges. During the hearing, senior advocate Mukul Rohatgi argued that the High Court judgment encourages indiscipline by allowing students to bypass attendance requirements. The bench was also informed that the courts across the country are taking different views on the issue. The Uttarakhand High Court, for instance, had recently observed that allowing students with low attendance to sit for exams may prove quote-unquote counterproductive. Justice Sandeep Mehta remarked that students could start treating the judgment as a free pass to avoid classes altogether, asking why have they taken admissions. Justice Vikram Nath added that if students stop attending lectures, it raises a serious question about what teachers in these universities are expected to do. The bench also questioned BCI Chairman Manan Kumar Mishra over the delay in challenging the judgment, with Justice Mehta observing that national law universities are already suffering because of it. Importantly, the Delhi High Court had passed these directions while hearing a suo motu matter linked to a student suicide, stressing that attendance rules should not come at the cost of students' mental health. Instead of these strict rules, the High Court had suggested measures like attendance alerts, extra classes, assignments, and legal aid work to help students compensate for these shortages. So where should the balance lie? Discipline in classrooms or flexibility for student well-being? Let us know what you think in the comments. And for the sixth story, the Delhi High Court today reserved its verdict on the bail plea of Atahar Khan in the 2020 Northeast Delhi riots larger conspiracy case, but not before making some strong oral observations in the court. A division bench of Justice Pratibha M. Singh and Justice Madhu Jain was hearing Khan's plea when his counsel Arjun Diwan referred to WhatsApp chats to argue that Khan had opposed road blockades and was not involved in violence. But the bench questioned why certain messages had been deleted. At that point, Justice Pratibha Singh orally remarked that the chats, on the face of it at least, actually appeared to support the prosecution's conspiracy case. The court observed that the messages showed the accused acting together and warned that once such conspiracies begin, things can go out of hand, referring to the violence witnessed in 2020. The bench also remarked that the chats suggested Khan was an active participant. Opposing this bail request, Additional Solicitor General S.V. Raju argued that Khan's role was far more serious than some co-accused who have secured bail. He told the court that Khan's role could instead be compared to Umar Khalid and Sharjeel Imam. On the other side, Khan's counsel argued that there was no recovery of weapons, money, or incriminating material from him, and no evidence showing his direct participation in violence. The defense also claimed that others granted bail had played a more active role in mobilizing crowds. After hearing both the sides, the High Court has reserved its verdict. And for the seventh story, the Delhi High Court has ruled that simply registering under the Delhi government's Advocates Welfare Scheme is not enough to claim insurance benefits under it. Justice Anish Dayal dismissed a plea filed by an advocate who had sought reimbursement for medical expenses incurred during prostate cancer treatment in 2022. The advocate argued that he was already covered under the Chief Minister's Advocate Welfare Scheme and had even received reimbursements earlier for COVID-19 treatment and cataract surgery. But the High Court noted that the scheme required a proper verification of enrollment details and EPIC, that is voter ID information. According to the court, the advocate's voter ID verification remained incomplete because incorrect details had initially been submitted. The petitioner had earlier been issued an e-card under the interim court directions in separate litigation related to the scheme. However, the court pointed out that those interim directions were later stayed by a division bench, after which insurance coverage continued only for advocates whose details had been fully verified. The High Court noted that the advocate neither corrected the voter ID details within the given timeline nor reapplied when a fresh registration window opened in 2022. Rejecting the plea, the court held that the advocate could not claim reimbursement benefits when he was not part of the final verified beneficiary list during the relevant period. The court also refused to accept the argument of legitimate expectation based on earlier reimbursements, observing that the petitioner was fully aware that those benefits flowed only from interim court orders that were later stayed. And for a second last story, we have one of Delhi's most exclusive colonial era institutions, which is now fighting for survival in the court. The Imperial Delhi Gymkhana Club, spread across nearly 27 acres in Lutyens, Delhi since 1913, had been asked by the central government to vacate its premises by June 5th. The centre says the land located on Safdarjung Road falls within a highly sensitive zone and is now required for defence infrastructure and public security purposes. The club and its members challenged the move before the Delhi High Court today. Appearing for the members, senior advocate Abhishek Manu Singhvi argued that the government passed a final eviction order without even issuing a show cause notice. No hearing, no compensation framework, and no procedural safeguards. Singhvi also questioned the broad language used by the centre to justify the takeover, arguing that terms like public security and defence infrastructure cannot automatically satisfy the legal requirement of a clear and specific public purpose. Senior advocate Kapil Sibal took the argument further, saying a clause in the original lease deed allowing the government to re-enter the land for public purpose itself needs a constitutional scrutiny. According to Sibal, any clause that permits the state to take over property without due process is fundamentally incompatible with constitutional protections. Solicitor General Tushar Mehta, appearing for the centre, clarified that any eviction would happen strictly through due process and not through forcible action. The Delhi High Court has now issued summons in the matter and sought a written response within 8 weeks, but for now, the June 5th deadline remains in place. And finally, today, a Delhi University exam scheduled on Bakrid ended up reaching the Delhi High Court after students argued that they were being forced to choose between their exams and a major religious festival. The matter was heard by Justice Jasmeet Singh after a DU law student challenged the university's decision to hold an examination on May 28th. The same day, the central government officially shifted the Eid-ul-Azha holiday. The petition argued that the decision violated Muslim students' rights under Articles 14, 21 and 25 of the Constitution. During the hearing, Delhi University informed the High Court that students who wish to celebrate Eid-ul-Zuha will now be allowed to take the examination after July 4th. Recording the submission, the court directed that affected students must inform the Dean of Faculty of Law through email by Wednesday, and the university must communicate the fresh exam date at least 1 week in advance. The matter was then disposed of. The plea had pointed out that several constitutional institutions, including the Supreme Court itself, had already shifted the Bakri Eid holiday to May 28th in line with the centre's notification. The student argued that despite this, Delhi University continued with the examination schedule, effectively placing students in what the plea described as an impossible situation: either appear for the exams or miss important religious occasions and family celebrations connected to Eid. That's LiveLaw Daily for today. You can find the list of stories discussed today in the description box along with the links, and keep following LiveLaw on all our socials to stay updated with everything that is law.